Can't get enough of Kelly and Ramya?
We're now on YouTube for you to indulge in highlights from our show.
It's time, though, folks, to get into our Know Your Rights segment. Let's welcome in Danielle McLaughlin.
Did you know that everyone has rights? No matter who we all qualify. But what happens when freedoms collide? The answers are rarely simple, but always interesting. Join me, Danielle McLaughlin, to talk about civil liberties and human rights on Know Your Rights.
Always get excited on a Monday, Danielle, because you bring us so many entertaining questions, so many things to make us stop and think, and more than that, some wonderful guests to help supply some great answers. I turn the floor over to you.
Thank you so much, Kelly. Well, I'm very excited today because we have a special guest with us. Anita Szigeti is a lawyer and founding member of WICKED, isn't that wonderful? Women in Canadian Criminal Defense. Anita teaches and publishes extensively on mental health law, an area in law in which she is maybe the preeminent expert. Thank you so much for joining us today, Anita.
Thank you, Danielle. I'm really honored to be here. Thank you so much for including me. Such a great show.
Well, I'm very excited to have you. Now, mental health law is clearly a very important area of practice, and it covers both criminal and civil matters. So could you please just give us a quick overview of some of the barriers to justice that people with mental health challenges encounter?
Sure. So people with serious mental health issues, of course, face all the same barriers as other individuals with poor social determinants of health, who have low or no income, do not have safe housing or access to phones and so on, which makes navigating legal systems and even knowing where and when to show up for your case a challenge that is sometimes almost insurmountable. And that's before we even take into account how difficult it is to get legal aid in the first place, and then to find a lawyer who's prepared to spend the time that you need on your case on a legal aid retainer, which is so low. But in addition to all that, people with serious mental health issues face systemic barriers because the justice system does not cope well with serving their interests. And there are two main reasons for this. First, the pervasive stereotypes and prejudices about people with serious mental health issues extend deep into the justice system. Those stereotypes fall into three main categories, namely that the client population is one, dangerous, two, cognitively impaired, or three, cannot make decisions for themselves and must have others make all their important decisions for them. Now, these are, of course, all false myths and prejudices that result in discrimination. At the same time, individuals in the midst of emotional crises do need accommodation, most notably additional time to process information necessary to participate meaningfully in their own legal matter. And the justice system, often including their own lawyer, is not set up to afford these clients the time they need to engage with their litigation. The entire justice system is geared toward maximizing efficiency, and therefore access to justice, due process, and fairness in proceedings do suffer in the process, with disproportionately adverse impact on those who need additional time and resources to understand and appreciate how their rights may be affected and the processes involved. So those are really the main barriers: access to justice, systems that afford the individual autonomy to make their own decisions, legal aid, and lawyers who are expert in the particular proceeding and can take the time and will take the time necessary in court to accommodate the person's needs to follow along and process what's happening.
These are really important concerns, and I think some of them hold true for people with all sorts of disabilities. That the assumption that you're cognitively impaired if you have another sort of impairment, I think is huge. The issue of agency. But one of the things that we hear about frequently in the media, some people are concerned about accused people being declared not criminally responsible because of a mental illness. In your opinion, is this a safety issue for the community at large?
No, there is absolutely no safety issue for the community that results from a verdict of NCR or not criminally responsible. The fears that people sometimes have are based on misinformation and sensationalized media accounts of very rare, seriously violent incidents that occasionally lead to NCR verdicts. The vast majority of people found NCR now have come in contact with the criminal justice system with low level offending, simple assaults, or even mischief or theft, maybe uttering threats or breach of probation. They are not sort of wildly dangerous people to begin with. But even where there is that rare violent offense, contrary to popular belief, when someone is found NCR, they are not acquitted. They do not go free. NCR is not a get out of jail free card. People are not getting away with murder. Instead, they go into a separate stream of the criminal justice system, the forensic psychiatric system, and they usually start off detained in a very secure psychiatric hospital. They will often remain in hospital for many years. And then slowly the restrictions on their liberty are loosened and they might get some off-ward passes and community access and eventually get discharged from the hospital. But even when they're living in the community, they are under constant, very strict supervision. Their medication compliance is supervised. They are routinely screened for drug use and must report to their psychiatrist regularly, subject to a host of terms and conditions. People found NCR will spend many years, 10 years on average, under the jurisdiction of a specialized tribunal that reviews their case every year, slowly reintegrating them into the community. And statistics are clear that while under the review board and after finally receiving an absolute discharge, the likelihood that someone found NCR will reoffend is much lower than had they been found criminally responsible and gone to jail. That's because in jail, people with serious mental health issues tend not to get treatment for their condition, while NCR accused receive treatment that is intended to reduce their risk. So from the community safety perspective, it is a much safer option than convicting individuals and jailing those offenders.
And one of the things people forget is that eventually almost everybody gets released. So certainly helpful to have somebody treated for a problem than just being warehoused for an extended period of time. I understand that also in some cases, people who have been declared NCR are, under scrutiny for longer than had they been convicted of the offense without that designation.
Absolutely. And there are people who come in who would have got time served if they'd pleaded guilty or been convicted and end up in the system for, 6 years, 10 years, 15 years, 20 years. I have a client who stole a bag of potato chips who's been detained for 8 years now in secure custody.
Oh, dear. Well, encounters between police and people in crisis have sometimes ended tragically, and there are many such things in the news on a daily basis. In your opinion, do you think that police have sufficient training to deal with people who are experiencing a mental health emergency?
Yeah, Danielle, there can be no doubt that persons in crisis, and in particular, Black people in mental health crises, are disproportionately killed by police. Where this was once only known anecdotally because police did not keep the necessary statistics, it's clear now. And people have tracked these numbers. Most, if not all, of those deaths are entirely preventable. So why do they still happen? Is it a question of training? I'm not sure anymore because as a result of a huge number of recommendations from inquests into these deaths over more than 20 years now at least, training has really improved within many police services, if not all. Toronto in particular has really revamped its training on interactions with persons in crisis after the Yakabuchi report and recommendations from the inquest into the deaths of Rael Jardine Douglas, Sylvia Cliven-Gatis, and Michael Elegon. That was known as the JKE inquest in 2013 or 2014. So the next question really is, why is the training not translating into action on the ground when the frontline officer encounters someone in crisis? Part of the difficulty is, of course, police culture, which is really about commanding and controlling every situation and containment. De-escalation takes time and patience, lots of time and space to the person, which runs contrary to the basic earlier training, at least around use of force. but definitely emphasizing that de-escalation is the primary goal and must be attempted first and repeatedly throughout every interaction is now part of all of that use of force training. So I think there are other areas that we have to focus on next. Things like communication between members of policing teams and partners, all those who attend on a scene, giving individual officers license to intervene if their partner or colleague is escalating a situation, involving people with lived experience of serious mental health issues in policy decisions and training within every local police service, not just Toronto. But probably the best way to prevent these deaths is removing policing from the crisis response altogether. And as you likely know, Toronto has at least 3, I think maybe now 4, very successful pilot projects that have done this in the last year or so. And the answer, I think, does lie in community-based, well-trained crisis workers who are not mental health professionals either, so not psychiatric nurses, but probably the best model is peers, others with lived experience of mental health issues who have received extensive crisis intervention training. Because people in crisis are very frightened of police, whether in uniform or not, but they're also terrified of psychiatrists and mental health nurses who they fear might put them in the hospital against their will. So I think for most situations involving a mental health crisis, other than maybe where a weapon is involved or immediate danger to life is an issue, there really is no role for police. And I think both the clients and police would be happier if they were just bypassed and relieved of the responsibility to attend on these calls altogether.
And besides, those people would unlikely be armed, which automatically makes people a little bit safer. So yeah, this is a huge improvement where they have units that can go out. But you know, many, if not most provinces have mental health acts. Can you just give us a briefing? What is the purpose of this kind of legislation? And, you know, the 3 basic questions, does it work? And what are some of the side effects of that kind of legislation?
That's a really good question, Danielle. The overriding purpose of these civil mental health acts is a point of contention among academics. There's no clear answer, which I think is largely because no 2 mental health acts in Canada are identical. Every
Uh-huh.
province and territory does have one, but they're all different because mental health is a provincial responsibility or power. So the competing purposes are, on the one hand, protecting the public safety from dangerous people versus protecting the individual from themselves on the other hand. The short form for these models is usually the dangerousness model versus the so-called treatment needs model. In
Mhm.
Ontario and in a number of other provinces, we have both. Usually the older legislation focused only on forcing people into psychiatric detention when they pose an imminent serious risk to themselves or others. We have largely moved away from that to a much broader net. We can now cast over people in order to lock them up against their will for more paternalistic, benevolent reasons, such as, for example, forcing them back onto their medications or into substance use treatment. At the same time, we've also lowered the threshold for risk of harm that is sufficient to meet the criteria for involuntary committal. So in Ontario, we have cast a really, really wide net in this regard. In Ontario, under these expanded committal criteria, a person who meets certain other conditions can be detained against their will for simply being at risk of substantial mental deterioration over time if they do not take their medication, for example. So that's a huge percentage of individuals with serious mental health issues who might well meet that very vague and very broad criteria.
Yeah, this is an issue that I think will continue to arise. Unfortunately, there, as you said, there are the myths and basically the prejudices that end up with people being committed where there might be other options available. And I think it's people like you, Anita, who help to bring this to the foreground so that we understand, you know, that there might be different options. Now, we don't have a lot of time left, but I would really love to ask you, you know, if you could um, make policies, and obviously you are contributing to making policies, but regarding mental health law, what would you like to see changed?
I really appreciate that question. I'll quickly just highlight 3 things, and I'll just summarize the 3 things that I want to see change. First, There's my abolitionist aspirational goal: no secure psychiatric facilities. I don't think we need psychiatric detention at all. It's very, very few people who need that, and people should not be caged, whether in prisons or hospitals. Second, if we are going to lock people up, let's not lock them up forever. Both the civil and the NCR stream allow for indefinite incarceration and detention, and there should be caps and limits on the kind of time we hold people in these situations. And third, we really need to look at the role that race plays in who is offered a voluntary short-lived civil admission to hospital versus who gets charged with a criminal offense, found NCR, and detained forever. And Black men are so disproportionately represented in forensic psychiatry that we need to look at that in the same way as we do at over-policing and over-incarceration of Black people in our criminal justice system. So those are my three top wish list items.
Well, thank you so much, Anita. These are enormous, and I think that our listeners need to think about what you're thinking about. Thank you so much for joining us today.
Thank you so much, Danielle.
That was our special mental health law expert, Anita Szigeti, talking with us today about the barriers to justice that people with mental health issues come upon not infrequently, unfortunately.
Wow, Danielle, fantastic. What a conversation. Thank you and Anita both. A lot of information there. We'll talk to you later in the week, and we'll get you back on here for your next segment next week.
Thanks for watching.
You can catch Kelly and Ramya weekdays from 2 to 4 p.m. Eastern on AMI.